Okay, well, good afternoon, everybody, and welcome to this bite-sized relaunch event of the Northern Administrative Law Association, which we call NALA. It coincides with the 15-year anniversary of regionalisation, which is something that I just realised when I was thinking about the dates, because I think the working party paper, the judicial working party paper, was first produced in 2006 and regionalisation happened in 2007. But when looking at the paper those many years ago, which was then produced by the president of the Queen's Bench Division, Sir Anthony May, he said that proper access to justice is not achieved if those in the regions can only issue judicial review and other claims in the administrative court in London. And so I think that sentiment is true as it was then, as it is now. So NALA essentially relaunches itself today as a cross-profession and cross-penile association, with its aim being in the development and strengthening of practice of administrative law in the Northern and North-Eastern Circuit. And to this end, I would really urge those of you who want to be involved in the new committee and in its development to strengthen administrative law in both circuits to contact us. The email address is in the chat function, but for completeness sake, it's nala@kingschambers.com. So, to mark this relaunch event, I'm delighted that Sir Michael can join us this afternoon. As many of you know, Mr. Justice Fordham, when in practice, I found on Google, argued more than 50 cases in the UK Supreme Court and House of Lords, including most recently the Miller case before he was appointed. For over a decade, he represented the UN High Commissioner for Refugees in leading asylum cases, and of course writes the leading textbook, the Judicial Review Handbook, which is no doubt on all of your shelves. He was awarded several awards during practice, including Human Rights Law of the Year, Bar Pro Bono Award, and the Public Law QC of the Year as well. He was appointed as a High Court judge in January 2020, and plainly, and I hope you agree with this, Michael, the apex of his career came with the appointment as the Northern and North-Eastern Liaison Judge of the Administrative Court. He is very enthusiastic about the regionalisation and ensuring the strength of administrative law in the regions. And I'm delighted, first of all, that he was appointed our liaison judge, and secondly, that he's agreed to talk at this event about practical tips on appearing in the administrative court. So I'll hand over to Sir Michael straight away.
Thank you very much. Thank you for having me. And yes, absolutely. I really wanted this job, and I'm very happy that I got it. So the rebirth, the relaunch, I think it's important to say that it's entirely appropriate that the judges of the court should have engagement with the practitioners who practice in the court, and that engagement shouldn't just be in our court. So that's why we have user groups, for example, but things that you are going to be doing as NALA are, where appropriate, going to be things that our judges of the admin court should also be able to be involved with. And I know we've got several who are joining this evening. So that's, I think, a start of that, with more to follow. I can see how many participants we've got, and I can see the numbers. So if they start going down, I'm going to take it highly personally. I'm excited that you are solicitors, in-house lawyers and barristers all in the same association, because not all associations do that, and it is an obvious virtue. From my perspective, the fact that you are the North, so Northeastern Circuit and Northern Circuit, is also very good, because that happens to fit with the two roles that I have. So look, some tips. Some of these you'll find bleeding obvious, like civil faulty, and that's fine. I don't mind being the affirmation or reaffirmation of what you already know. Some of it you'll find, perhaps a lot of it you'll find, may read across to any time you are coming in front of courts, and that is also fine. But let me tune you in to our side of the court to just reiterate some things that matter from a practical perspective that you may be able to take away and make sure you're doing. So let me start with not the hearing, but the very important run up to the hearing. Whatever that hearing is, whether it's a substantive hearing or a shorter hearing, because the pattern, I think, is always very similar. And the more we can tune into each other, you and me, my team and practitioners, the more effective we are all going to be in the enterprise that we're involved with, which is justice in the public law sphere. So in the run up to the hearing, what do you think I most need as a judge? What do you think is the worst thing for me to get as a judge? Well, where I start is with my reading. What am I going to read prior to the hearing in order to tune in? And that starts with document management. And every minute I have to spend on document management is a minute less on reading the documents and tuning in with the documents. So the most important thing you can give me is a proper, decent pre-reading list, liaising between the parties, making sure it's up to date, making sure it's referenced to the most up-to-date bundle, making sure that if some point's been abandoned, then I don't get sucked into stuff that is not going to matter anymore. I need a realistic time estimate for it, and it needs to be focused. And you're not going to know how long I'm going to have to do it. So let me tune you in to the sorts of practicalities from our end. So if I've got, say, 3 hearings to do on Thursday, and when I say I'm speaking for my colleagues within the court who are likely to be in a similar position. Let's say yours is one of 3 or 4 hearings I'm going to be doing in a renewal list on Thursday. You may assume that Wednesday is going to be my reading day, so that's fine, isn't it? You can leave everything till the last minute, and then I'll get to slot it all in and do it in one go, and that is often simply going to be wrong. My reading day for those hearings could be the Monday. I may want to get ahead of the game the week before. I'm going to want to read it once. I'm going to want to read it in a way that is effective and efficient. So, here are the authorities. The afternoon before the hearing is very, very bad news. Bundles. We want you to include everything we need, but only everything we need and nothing else. We need the bundles to work in hard copy. Some of us will work from electronic, some of us will work from hard copy. I tend to use hard copy for a hearing, but I want the electronic for after the hearing. If I'm reserving a judgment, I'll often be searching stuff, blocking and pasting it in. I want a good and proper index, not a lazy index that says item 12 exhibits. A proper index that is going to help me track things down. And I need your internal cross-references to work and to work to the latest bundle. So if you do decide to change them all and change the pagination, then you're going to have to think about whether you need to redo the references in the witness statements or in the detailed grounds, because otherwise I'm going to go to something, I'm going to look for something, it's not going to be there because the pagination has changed. And I know this is obvious, all of this, but you would not believe how significant these kind of things are in our lives on a day-to-day, a week-to-week basis. And, you know, if you are doing an electronic bundle and you've got some using that and some using the hard copy, and the pagination doesn't work because the index didn't count for the pagination. So for everyone electronic, they go to page 11 and it's different from my page 11 because I'm working for the hard copy or vice versa. That again is just really bad news for all of us. Authorities, I want the law reports to be used for the case law. And again, you would not believe how often we just get lazy, here are the transcripts. And you might say, well, what's the problem with that? And why are these judges so grumpy about something as straightforward as that? The judgment is exactly the same. Yes, it is. But I might want a quick way to understand the context in which this passage of principle was spoken. And that's why headnotes are so important, because that's what they give me. And legislation, if you only take one message away from today, let it be this. It's really dangerous to cite what you think is the only relevant section from the Act or the only relevant regulation. It is really, really dangerous. It is almost inevitable that the court is going to need to see around it, is going to need to see how it works as a whole. What's even worse than here is a section of the Act is here are 6 or 8 sections of the Act, each with their own tab in the bundle of authorities. So just don't ever do that. Think about what's the part of the Act that is relevant. I'm not saying you have to have all 500 pages of a statute, but to think you can just get away with section 12 is really dangerous territory. And I find constantly, my heart sinks when I see that it's all zoomed in. And I know that there's going to be nutrients to get from that statute or those regulations read as a whole, which means what am I going to do? Do the research myself, make you do it, and provide the legislation in a fuller way. So that's why I've taken some time with that one, because that one I think really, really matters, particularly in public law. And it's the same for other instruments, policy instruments, planning policy instruments. Skeleton arguments for a hearing. They are multi-purpose documents. And of course, now we've got these new rigorous rules in judicial review, Part 54, about page limits, and a pretty tough rule about not incorporating documents by reference. So you will make some judges very grumpy if you try and incorporate your 64-page grounds or even your 20-page grounds into your 20-page skeleton, because what we are supposed to have is a one-stop shop. And we know that document has to work in a number of ways for you. You have got to get the penny dropping when we pre-read. So the headline points have got to come across for us. It's got to be comprehensive enough so that we can nail down a point if we're particularly interested in it, or if a point is particularly contentious. We've got to be able to chase it down. It's also got to be the document we can carry around with us that's going to work for us before, during, and after the hearing. And that does give you a bit of a dilemma as to whether you're going to set out passages from authorities or whether you're going to expect us to just have the paragraph number and then carry the page or go to the authority itself. And you're just going to have to strike a balance with that. And we understand that. So that's the run up to the hearing. And I'll come back to the hearing, but let me go back to the course of the proceedings that you are dealing with and we are dealing with. And we understand, I think this is true, I hope it's true, that we understand your position. We haven't suddenly forgotten what it's like. We don't suddenly think you've only got one case to deal with in your lives and that you can be maximizing the attention you give it at any point in your calendar. That's not realistic, and costs would go absolutely through the roof if practitioners were expected to do that. But the hot spots are, you've got your PAP stage, you've got your pre-action stage, which to some extent is warming up, may not be very relevant to us, the judges, by the time it gets to us, could be. Then you've got your claim stage. I've just realized it seems very bright. Just changed my angle. And your claim stage, the commencement stage, obviously, particularly in judicial review cases, lots of work goes in at that stage. Mandatory for the claimant, optional for the defendant and interested party. If they want to play at an early stage, they get to play. That's their choice. And lots of things are going on at that stage, but we do expect rigor at that stage. And you should be thinking about things like directions and any special orders that are needed. So if you need anonymity or you need permission for expert evidence and you're the claimant, we want to know about that at the start, because we have this opportunity for a single judge to do a good job with case managing the case at the permission stage. And every time we have to have another judge looking at the same case for the purposes of case management, that is inefficient and something that we want to avoid. So that's a hotspot for you, and it's a hotspot for us. Then in a judicial review case, we know what happens post-permission. There'll be a whole defense and evidence stage. There'll then be possibly a reply stage. That is a stock take moment for a claimant. And you need to take that opportunity again, because we will expect rigor. If, for example, you're going to amend your grounds, then you want to do that early so that you are protected against the court saying it's far too late in the day to change the shape of the case. So if something is happening, something that's arisen out of the defense or the defendant's or interested parties' evidence, you've got to be on it as the claimant at that stage. And then we've got the preparation for the hearing and the hearing itself. And we all know by the time you get there, the focus is likely just to be on the skeleton arguments. So what are the pleadings doing in public law? They are really setting a fair framework for the arguments that are going to be developed, so that your opposition party can't turn around and say, well, this isn't within the framework of the pleaded case. And providing you tick that box and you've given a fair framework for what you're going to argue, we can all just get on and focus on the skeleton arguments. Now, you need to use this book. On mine, it's coming back to front, but it's the Administrative Court Judicial Review Guide. It comes out every year, and it's a really important book. Why? Because it's edited by judges, so it is coming from the horse's mouth. It is up to date. It's up to date with the authorities. It emphasizes the things that matter from the court's perspective, and it's publicly available. So litigants in person, whoever's using the admin court, will have access to this book online, and we use it all the time. And we expect the standards that are described in there and the principles in there to be adhered to. So you need to make sure you're tuned in with them. It's often a really helpful guide for you to be able to reference rather than having to rehearse principles. So let's say, I don't know, basis on which the administrative court will accept expert evidence. It's all set out in there. Principles that apply to interim relief. It's all there. So use it as your shorthand, as your reference point, because we do, and you need to know that we do. And I think to a lesser extent, the White Book, because it doesn't have all of those virtues that I've just described, that this book, I'll show you it again, has. Make sure you've got it and make sure that you use it. For paper applications, again, it will, I think, help you to know and think about the realities as they apply to us. Because if you can put yourselves in our shoes, you will be able to help us better. So let me give you an example. I've got a paper apps day coming up later this week, and I will probably have 8 sets of papers to do in a day. That includes reading what both sides are telling me, deciding what order I'm going to make, making my order, writing my order up, and giving my observations. Now just pause and think about that. And then think about what I need from you, given the practicalities of that sort of time frame. Because important though your cases are, we are not going to stay up all night doing them. We are going to get them done within the time frame that we have to do them in. And that tells you a lot, I think, about what we're going to be looking for in grounds and acknowledgements of service and other documents. We're looking for draft orders. We're looking for practical assistance so that we can nail it. And we know perfectly well that your grounds for judicial review are there as an appetizer to try and get us to give you permission. And they're also there as the fair framework for the case. So that's just a practical tip as to what's going on. If you're making an application during proceedings, what do you think we are most interested in when we first come to the papers? And you would be exactly the same. I want to know, what do they want? How urgent is it? Do I have to deal with this today? Have the other parties responded? So have I got everybody's say on this? And so you can help the court staff no end and the judges if you're making an application by being very clear. Have you served it? When did you serve it? Who did you serve it on? Have they responded? Even if it's to say, we're not going to respond, or we agree, or we don't agree, or we're going to put something in 7 days' time. We want that information to be upfront, because otherwise the staff have to chase and chase in a way that they shouldn't have to do. And if you're seeking something by way of an application, then I want a draft order. Don't say anonymity and leave it to me. Let's have a draft order so that you actually spell out what it is that you want the court to do, and liaise with each other and agree what you can. Beware interposing a judge beyond those hotspots that I have described. The model works really well when we've got a case management judge at the beginning, and then we've got a substantive judge at the end. And we recognise there might be a need for more of us to be involved. If one of us refuses on the papers, you're going to need another one to look at it at an oral hearing, for example. And if there's a need for something to happen during the proceedings, well, a judge is going to have to look at it. But beware, don't put in, can we please have the acknowledgement of service in 14 days instead of 21 with a right of reply within 7 days? Because just think about it, you're getting another judge to parachute in just for the sake of that, and they're going to look at that to see, is that really truly justified? And I had 2 of those today. Do not communicate with the court unilaterally. If you don't know this, find Rule 39.8 and read it in the White Book, in the CPR. And I have had this so many times, I'm sure my colleagues get it as well. And it's really bad practice to think you can make some point to the court that's going to be seen by the judge, but you didn't bother to CC the other parties in the case. And I've particularly seen it with cases involving litigants in person. Oh yeah, we didn't copy in the litigant in person. Well, why not? And if you wouldn't have left them off if they'd been a posh firm of solicitors, why are you leaving them off because they're a litigant in person? Consequentials at the end of a case when we're handing down a draft, getting ready to hand down a judgment, and you're getting it in draft. What's good, what's bad? I'll tell you what's bad, I think, is leaving it till the last minute. Here are the corrections. And, oh, yeah, we haven't really liaised about the consequentials. So we've agreed 7 days for them, 7 days for them. What do you think we want? Again, put yourselves in our shoes and you'll get it. And I promise you, we will try to put ourselves in yours as part of the same deal. We want to get rid of the case. We want to decide the consequentials while we can still remember it. And we probably want to explain what we did about them at the end of our judgment. So use that time frame, work out what's contested, work out what's agreed, provide the submissions, and let us deal with everything at the time of handing down the judgment. Right, finally, let's go back to the hearing. I talked about prior to the hearing. So now let's swoop into the hearing. And again, whatever hearing it is, and you'll forgive me, I hope, if all of this is equally applicable to other cases. I'm just telling you it from our side of the fence in the admin call. You can expect engagement from us, as you know. And I've come round to just in the end thinking I just can't apologize about that, because that's what makes an oral hearing come alive. And yeah, you know, you'll wish that you could put us on mute and just get on and make your speech, and understand that. I remember those frustrations. And you're there to do your show and tell, and you're there to do your thing in front of your client, and you've got things that you came to say, and you're against the clock. Understood. But you do need to know what we're getting and not getting, and whether we are tuning in, and whether we can see a difficulty, in which case we're going to put it to you. And I know you know all of that, and I know that you embrace it, but I think it's important for us to say that and recognize that. And please, when we ask you a question, if you're the advocate, even if you need to pause and take a breath and take a moment, please will you not be on the Today programme as a politician being asked a question by a presenter where you just use it as an opportunity to say what you want to say. I'm caricaturing that, but I'm giving that as a contrast. It has possibly happened occasionally on those kind of programs, but don't do that with us. It may be a good question, it may not be a good question, it may be helpful or unhelpful. It's very unlikely to be there to trip you up. We're just trying to understand and get to grips with it. But if we ask a question, please answer that question. If you've got something else to say, that's fine. And if it's a but, or if it's a, well, another question is this, and the answer to that, or even if it's a, I'd like to think about that, or I promise I'll come back to that, as long as you do come back to it and you're not just trying to avoid it. Again, it sounds so simple, but if you could sit where we sit and have that experience of then, well, what do I do now? Am I going to ask it again? Am I going to be gentle and ask it again? I just wonder if I could come back to my question. Citing authority, and I think I've run out of time, so here is where I will finish. Citing authority to us. Focusing on case law in public law. I think as with other areas, you can expect your court to be thinking, what's the point of going to this case? And you can expect us to be thinking, why have I got so many authorities? Why do I need a bundle of 30? You can expect a court to be thinking, which 5 am I going to really need? And which are the ones that are going to feature in my judgment? And that will help you if you also think in that kind of way. But just some practical tips on that. How to select your source. Think in particular about recent and higher altitude. Because if in your bundle you've got a recent Court of Appeal or Supreme Court case that is in a particular area, it is highly likely that that will give you pretty much all you need. And to take us through a historical trawl of where some principle came from is unlikely just to be worth it. If we can get it from Lord Reed yesterday or from the Court of Appeal last year. So that's to do with selectivity. And part of the problem is people have a kind of block and paste thing from previous cases they've done. Oh yeah, I did the law on that last time. So here it is again in 10 pages. So please try to avoid that. And in terms of the examples you're going to, we're going to be thinking, why are we going to this example? And final tip, you're going to go to a case for one of 2 reasons. One, you're going there for a statement of principle that helps us. And that's fine. We understand that. We just need to know what is it and where do we find it? Thank you very much. Move on. There is another use for authority in public law, which is harder, I think, because some judges don't like it. And that is, here is a working illustration of principle in action. It's not this case. It's a case on its own facts, but here's what happened in that case. And I think providing you do it sparingly and providing you just test the waters with whether you think this judge, this court is going to be assisted by that kind of thing, I will give you my take on it, which is I think that can be really, really valuable to use authority in that way. Not statement of principle, but working illustration of principles in action. And if you've got a judge who's not very familiar with a particular area, that can be particularly valuable to see some examples. You get more of a feel for it that way. So those are the practical tips. Thanks again for having me and for having my colleagues that have joined you. I wish Nala all the best. And I don't know what you want to do, Sam, about a couple of quick questions or whether you want to just leave people to go back and finish their skeleton arguments and write their reading list for the hearings they've got coming up.
Yeah, we can take a few questions if anybody has them. You can put them in the chat function whilst anybody's doing that. Thank you for that talk. I think I learned, and most of us learned more in that 30 minutes than 5 or 10 years in practice. in the admin court. So thank you very much. But yeah, if anybody has any questions, then please put them in the chat function. It's already active because I put the email address of Nala for those of you who want to be involved in setting up our program and being involved in what we do. So we'll just wait a few moments. One question I do have, and it's a purely practical question because someone else just asked me. You showed a hard copy of that handbook. Where on earth do you get a copy of that? Because we've never been able to get a hold of a hard copy.
I don't know, actually. I mean, I can tell you that the first thing I did as liaison judge was to check with my judges who sit in Leeds and Manchester to make sure that they had a hard copy if they wanted one. But I don't know the answer to that question. The answer to that question might be that I'm sorry, but you are going to have to print it up because it's available. And all I'd say to you is just print it up and keep it handy so you don't need to keep printing it up.
I think there's one comment there, if you can see it.
Let's see if I can see that. Right. So is this permission stage reply that person is talking about, or reply generally? Because there's two sorts of replies you might have. One's permission stage and the other is once you've got the detailed grounds of defence in, whether
yes,
you
I think it's permission stage.
All right, permission stage reply. So let me tell you my own personal take. And again, you will find that different judges take different positions on this, which is not easy for you all. The official line is that if you put in a permission stage reply promptly, it will be put to the paper judge, and the paper judge will decide whether to let you rely on it. So don't put in an application for another judge to parachute in to deal with that. You don't do that at the moment. Of course, this can change because it's quite a hot topic at our end as well. I welcome them if they are proper replies that are done speedily and they are concise, because I think, how many areas are there where the defendant gets the last word? And if you're not careful, you end up having a lot of renewal cases that are unnecessary because the claimant doesn't get to make their reply point until they get their renewal into open court. But that's my personal take on it. It shouldn't be something that's just an opportunity to repeat stuff or to, still less, change your case and argue some other case. But I think proper reply points. So for example, pointing out what's common ground, that's a proper reply point. Or dealing with a point that has been raised that maybe wasn't dealt with because you couldn't foresee it. Or saying, yeah, they've relied on this authority, but that's been answered by a more recent case. Those are proper reply points. But you've got to do it fast, and you've got to keep it brief, and you've got to make sure you do it with discipline. And I will tell you, because it's a fact, that I used to do them when I was the claimant. Not all the time. The reply at the substantive stage, quite often the directions will allow for a reply. I think if you're really changing your case, you've got to amend your grounds. It's not enough to rely on it simply as a reply. I don't think I did used to do substantive replies. I think if the grounds needed changing, I would amend the grounds. Otherwise, it just waits for the skeleton argument. So hopefully that's picked up on whichever reply the question was raising.
Yeah.
Okay. I think we're done.
Yeah, and I think there's the link there for the guide, if anybody wants to see it. But yeah, I think that probably takes us to the end of this event. Thank you once again for the short talk, and thank you for those of you who have attended. And just to reinforce the email address that I put on the chat function for those of you who want to get involved in the work that Nala does. But
Sam, can I just add one point on the user group?
Of course.
So this is my own sales pitch in return. We have user groups for the Leeds Admin Court for the North Eastern Circuit, and we have a user group for the Manchester Admin Court for the Northern Circuit. Those are open to anyone. We do them online, and they're short meetings. So if you have any interest in that, please let NALA, the NALA executive, know. They've got my email address. They've got the email address of my clerk. You'd be very welcome, even if you just want to try it out, because that's our part of the deal in terms of outside the court engaging with you. And what's different about that experience from you is you don't have to sit and listen to me. You can sit and talk to me, and we will listen to you, and we welcome that. So I would urge any of you who are interested to come and join us in those user group meetings. Thank you very much.
Not at all. Thank you very much, everybody, and I hope to see you soon.